my ruling?
Well, first thing is I would respectfully disagree. Twice you said, Mr. Parsons, I gave you a chance. You could have contacted them.
All right, we're done. Thank you. You can log out. Okay, any other setovers, continuances?
That might be mine, ma'am. I'm Dan Parsons.
Okay.
It had been set over 2 weeks.
Okay, Mr. Parsons, I have you on number 6. This is 242-007-0108. I have Ms. Adigbate here on behalf of Quantum Residential. So, Mr. Parsons, are you asking for more time, or are you just stating previously you were given more time?
Both, I guess. What, ma'am, I don't think they have personal jurisdiction. I don't think they have service. The service was done by mail and posting and mailing, but they didn't provide the information to meet. I think it's 59, 20, or 8.
All right, so hold on, Mr. Parsons. Hold on. When we were here last, I asked you if you were going to be screened for counsel who could help with these legal arguments. You said yes. I don't see that you have counsel here today. Did you go through the eviction defense screening line?
I felt a little bit rude to use resources from that council, having done probably 1,000 evictions myself in my job. So I did not contact them.
Okay, so you're planning to represent yourself?
Yes, ma'am.
Okay. Have you filed anything with the court?
No, and I debated that because my question is jurisdiction based on service, and my hope was at this hearing to apprise the court and council that they don't have the information sufficient to show that posting by mailing and service by posting and mailing would be sufficient. In the old days, you needed to get an order. You had to have your service person attempt service, and then they would say, okay, I tried this time, this time, this time, these days, and these, and at this time, and the time o'clock, I guess, is what I'm trying to say. I apologize. I'm a little sick today. I don't feel very well.
So are you asking to move forward with this argument today, or are you asking for more time?
The latter, ma'am.
For what? What are you, if I give you more time, what are you planning to do?
Expect for the landlord to show why posting and mailing was proper service. The law requires that you try typical personal service first. If not that, then you try substitute, and then if that doesn't work, you can post and mail, but you have to show at least 3 attempts, all different times, more than 2 days apart. I did a little research. I didn't realize the law had changed. Prior to 2019, you would go get an order that would allow for service by mail. And you'd submit your affidavit from your process server, so you know exactly, if you had an argument like, well, that's not right because I was home that time, or something, you could do that. It seems in 2019 they changed the law, and but it still requires a diligent attempt at service with certain specific requirements, and I see no affidavit that would support to allow for service by posting and mailing. And quite frankly, when I was looking into that issue, the 14-day notice has the same problem. The affidavit they submit says they posted and mailed, but as best I can tell, it doesn't seem to indicate that they had tried, they attempted service by by personal service or substitute service first, which is specifically required. It's just a form where they check,
Well,
here's
all
how
right.
I did it.
So you're agreeing that you received the summons and complaint and the motion in order to show cause, correct?
Yes.
You're just indicating that you believe it all needed to be personally served on you, absent an order from the court.
No, they changed. It looks like they changed the law in 2019. But what I believe is they still have to establish that posting and mailing was appropriate service in the matter. But you can't just go. It'd be what it'd be much easier just to mail this and post it. Let's do that. The law requires due diligence, and you have to try to serve personally first, and if not, that substitute service. And if you read the statute, it's like I say, it's I'm sorry, is it 5918? Are the landlord tenant statutes 5918?
Oh, I'm taking argument from you, sir.
Okay, well we'll call it.
I don't know what you're relying upon to support your position.
Well, it's whatever the statute for unlawful detainers. I think it's 5918.055. And it tells specifically what they need to do, and they should be an affidavit submitted to establish that they did duly and diligently attempted regular service. You can't just go. It's a lot easier.
Okay, you've repeated that several times. Ms. Adigbate, go ahead with your client's position.
Your Honor, there was 3 attempts at personal service of the summons and complaint and order to show cause. There's an affidavit of due diligence showing that on July 30th, 2024 at 12:03 p.m., personal service was attempted. There was no answer, and there were noises and or movement inside the premises. Again, on 8/1/2024 at 3:35 with the same notation of movement and noises. And then the third attempt was on 8/5/2024 at 9:12 a.m. There was no answer. So the affidavit of due diligence was completed and filed, and then an affidavit of posting that indicated that after those 3 attempts on at least 2 different dates at different times, that the summons and complaint and order to appear were posted and mailed. So it's plaintiff's position that Mr. Parsons had an opportunity to get legal counsel and chose not to, and that today his defense is proper service of the summons and complaint and order to appear, which plaintiff has established by sworn affidavits from the process server. So we are requesting the order only today, not a money judgment, since there was not personal service.
Thank you.
And my thing,
go ahead.
I have no reason to doubt counsel, but I didn't get that affidavit. And like I say, prior to 2019, you'd actually have an order with that attached. Looks like they changed the requirement to have to go to court and say, here's the information she just provided you. They would give an affidavit form. There'd be an order to allow service by mail. However, I didn't get that, so I can't respond to it. I can't say that was my birthday and there was 47 people here and the door was wide open or whatnot, because I don't know what their allegations were. I can tell you that I had no evidence or information of attempt by personal service. I'm here about 99% of the time because I have nowhere else to go. My cars, they can tell that my car's here. And so I guess I would ask if I could be provided that information, in kick it a week and give me that information so I could at least review it and see that if I believe that whether or not service is appropriate. How I can't argue against it because I don't have that the affidavit that counsel merely mentioned. The other option I was going to ask for is, because as you mentioned, Judge, I have seen the paperwork other than the proof of service, of service, proper service the way it should be. And,
All right, hold on, Mr. Parsons, I'm going to stop you there. I am issuing the order for writ. Service is proper. There's the affidavit of diligence in the file. I offered you the opportunity 2 weeks ago to be screened and appointed counsel. You have come here and declined that. You've indicated you received actual notice via the posting and mailing. There is no dispute here remaining. Do we have an order for writ on this one?
Your Honor, I apologize. We were not able to get that up to the court in time. Would we be able to email that to you, Your Honor?
So I don't have a judicial assistant in today.
I have one.
Do you on this one?
Yeah.
I might have something on this. Let me take a look.
So, Your Honor, I think we sent it up 2 weeks ago.
Okay.
We could just change actually, it might be fine to use that one. I don't think there's any date.
Yeah, I don't think so either. Let me just read through it quickly.
Okay, thank you.
ma'am,
Hold on, Mr. Parsons, just a minute. I'll indicate defendant appeared pro se. Yep, I can use this one. Okay, go ahead, Mr. Parsons. What would you like the court to know?
I think there's a misunderstanding. The court keeps commenting that I didn't seek counsel. Again, and there's a fair chance I've done more evictions than counsel for the plaintiffs in this case. I know I've been doing it longer because
Okay.
she's got 32 years of being an attorney under her belt. So
Okay.
I don't think I should be. There's criticism for me saying that I probably have more experience than the 1-800 number that was given, and I didn't want to take resources away from the people that aren't attorneys.
And
So that's what.
Hold on, Mr. Parsons. I didn't make any comment about your level of ability or non-ability. I asked you if you wanted to represent yourself, and you said yes. That's how we moved forward today. There is no dispute in the file. The writ is appropriate. I have signed the order for writ that was previously sent by Ms. Adigbate's office, and I'll hand that to the clerk.
I appreciate it. And
Thank
if I can finish my
we are done. No, we're done with this case, sir.
I can't put on the record for further action. You're not going to let me make a record of
what do you made your record, sir? What do you need to make a record of at this point? I've made my ruling.
Well, first thing is I would respectfully disagree. Twice you said, Mr. Parsons, I gave you a chance. You could have contacted them.
All right, we're done. Thank you. You can log out.
And the second one is we haven't addressed service on the 14-day notice.
We did, and I found it proper. This case is concluded. I have already signed the order for writ.
Well, I'm sorry what I did to annoy you to make you.
I am not annoyed. I am making a decision on your case that service has been appropriate, is appropriate, and I signed the order for writ.
The affidavit was filed with the court, but not given to me. That's not how the law works. You don't file things with courts.
Mr. Parsons, you are not here to tell me how the law works. Your case is concluded. I am ending your case and I am moving on to the next one. All right, let's recall number 2, the Moden matter, Mr. Kiernan and Ms. Baldwin. I did now receive the email. So let me turn it over to the parties to see what we are doing today.
So at this point, I did receive the updated email with an actual pledge of rental assistance. So given the law, they are entitled to 14 days. But I asked them to just send over 14 days, 2 weeks.